Yes.
Please, my Lord, I and Mr. Lutweza appear on behalf of the state.
Please, Your Lordship, I appear on behalf of accused 4 and 24, standing in for Mr. Biekes. On my own state, Your Lordship, I appear for accused 5, 10, 12, 13, and 14. May it please the court.
As the court pleases, I appear on behalf of the accused persons as before. Today, I want to be more specific. That would be accused 7, 8, 9, 23, 25, 26, 27, and 28. As the court pleases.
Yes, then we've got Mr. Hatuikulipi.
Morning, Judge.
Yes.
Continue to be unrepresented.
Yep.
Represent the following accused 17, 18, 19, 20, and 22.
Yep. Mr. Shanghala.
Morning, Judge. The same with myself and the entity that I represent.
And then Mr. Mwatelula.
Morning, Judge. Continue to appear as before.
Yes.
Thank you.
Right, I see Mr. Gustavo is still indisposed.
Lord, as promised yesterday by the state, we, through the investigating officer, managed to get the medical certificate of Mr. Gustavo. We understand you were supposed to be discharged yesterday, but there were a few complications, and that he will be discharged today. And for the record, the state will want to tender the certificate, my lord.
And this information that you will be discharged today is what was given to you?
Yes, my lord.
So in the circumstances, we are still where we were yesterday.
That's correct, my lord.
And I can assume that we can resume tomorrow when it's available.
As the court please, my lord.
Unless anyone has anything to say.
My Lord, if I may, when the court used the phrase assume that we can continue tomorrow, can the court be more specific? In the light that, as far as my client is concerned, I faced a difficult task, that indeed they want to fire me already. Coupled with the fact that...
Sorry, can you just, you said as far as your client?
My client is concerned, I hold instructions that we must continue with the matter as soon as possible. And indeed, there's a threat already out that he wants to fire me because of this matter. Further to that...
So just to be clear, your client wants the case to proceed?
Continue.
Yeah.
That is instructions that I got yesterday afternoon. More particularly in terms of accused 7, 8, and 9. I'm also mindful of the fact that accused number 3 have given notice to this honorable court yesterday as far as applications that is still pending before this court and other 2 matters, the petition as well as the intended application for the separation of trials. So based on that, I'm a little bit in limbo as far as what will happen tomorrow, if it so happens that we come back tomorrow.
Yeah.
See, in the light of the petition that is before this court, the notice.
What are you saying in respect of the notice or the application?
As far as the petition is concerned, according to my understanding of the law, is that basically,
Which petition? You mean the one in the Supreme Court?
yes.
Mm-hmm.
As far as that petition, that application is concerned, my understanding of the law is that basically everything must come to a standstill until such time that whoever have filed that petition, we have an outcome on that particular issue. So I just want to get, it's not a point of law, I just want to get clarity on that particular score as far as us coming back tomorrow.
Yeah, you're correct, but what is the position in relation to where a petition has been filed?
Basically, where the law then said that we must stop all proceedings because there is an interlocutory application, and the court, there must first be an outcome as far as that matter is concerned before we can continue with the main trial.
And that is on the authority of?
That is in terms of practice. There's not a rule that is pertaining to that, but
Yeah,
but
but-
the mere fact is an interlocutory application.
But you know that, like they say, practice is an unruly horse.
No, my lord. As far as this interlocutory application, so the interlocutory application must first be finalized in order for us to attend to the main trial. And that door has been opened by this honorable court as far as State versus Nigel van Wyk. When there was a petition pending, the court halted all proceedings here in order to get an outcome from the Supreme Court. And subsequent to that, we only proceed with the main trial, unfortunately. As the court pleases, that is my only submissions. Maybe I don't know whether or
No,
not
I still need more assistance from you.
my lord, I cannot take it any further.
But without knowing what question I'll put to you, you can still assist.
Okay.
All I was saying is this. As I said in my judgments on recusal is because if you were supposed to recuse yourself and you continue to deal with a matter, isn't it? All that is to no avail. Here we have got an application, a petition in respect of an application under Section 319. You are submitting that the situation is exactly the same.
But I'm referring to exactly the same as in terms of the interlocutory application. I'm not referring to the merits or the facts. I'm referring to the interlocutory application. So basically, there is the same avenue that we must follow.
Does it make any difference that the factual basis of the interlocutory application, does it make any difference?
It makes a difference as far as the main trial is concerned. What if the Supreme Court rule otherwise, as far as on the point of law?
Giving which example? Can you give an example?
If the court is of the view, the Supreme Court, that indeed this court was wrong in the decision, and the Supreme Court wants to hear the 319 application or the point in law and rule otherwise, then we are back to square one.
I'm just trying to think aloud. Of the points of law raised, which one is an example?
More particularly on the issue of Article 12 fair trial, the issues that have been raised on a point of law, whether or not the applicant in that particular matter, it is indeed entitled to legal representation.
Yeah. Now, how do we reconcile your client's position?
That is the reason, but I have a lifeline open there as far as the application for separation of power. I beg your pardon, not separation of power, separation of trial. That application is also pending before this court. My option there is that whether or not to oppose or to be in line with that particular application, but I must still apply my mind on that particular score.
Its effect on proceeding with the trial.
Indeed, sir.
And your submission is that that would impede the continuation of the trial.
Indeed, sir. But my lord, that
So
is
in
only-
other words, you're saying we have to wait until the application for separation of trial is disposed of.
No, my Lord, what I basically says that I just have placed my concern and submissions before this honorable court, and then maybe perhaps invite the other parties maybe to address your Lordship also on specific points. My only concern was that what is the reason for us coming back tomorrow?
Well, we are, so far, the reason we postponed yesterday was the absence of Mr. Gustavo due to illness. That was the only reason we postponed the matter yesterday. I don't know if there is any other reason in your conception which caused the postponement yesterday. And when Mr. Gustavo is here, it was of course the original plan or intent that we continue with the trial.
Indeed, so, my Lord.
Yeah. So if there are other reasons why we may not continue, we'll deal with them.
So can I then assume that if it so happened that accused number 1 is before court tomorrow, there is the plan of this court in order for us to proceed as far as plea taking is concerned?
That has been the reason why the matter was set down.
As the court places so noted.
But I'm concerned a little about the threat under which you are from your clients.
Unfortunately, that's part of the job.
Let's understand exactly what are you saying.
Basically, I hold instructions from my clients, more particular clients 7, 8, and 9, that they are ready all along to proceed with this matter, and that they are no longer part of any pending applications before this court, and that they want to continue with this particular matter as far as trial is concerned in order to test the evidence of the state, and maybe, God's willing, for them to be with their family in December like all of us. As the court pleases. As the court pleases.
So that would be in line with the continuation tomorrow, isn't it?
As the court pleases. Indeed, so.
I hope, Mr. Simunji, you are not under similar threat.
No, Your Lordship, but Your Lordship, I rise as an officer of the court. And just to echo the sentiments expressed by my learned colleague, Mr. Engelbrecht, Your Lordship, during the recusal application and subsequent petition of Nigel van Wyk, we had referred Your Lordship to ample authorities on the issue of interlocutory applications. And by law, Your Lordship, interlocutory applications, whatever nature, whether it's recusal, whether it's seeking for separation of trial, whatever nature, Your Lordship, they must be dispensed with before we can revert to the main trial. Now, from what I gathered yesterday, there's basically 2 interlocutory applications before this court. One is the petition. Of course, it doesn't directly, deal with this court, but it has an impact on proceedings of this court. Just like in the case of Nigel van Wyk, accused 10, this court had to stop proceedings pending the outcome of the Supreme Court. If it so happens that the Supreme Court dismisses the petition, then on that score of the petition, there is no reason why this court should not proceed, but the outcome is still pending. Then secondly, Your Lordship, there is an interlocutory application, the one of application for separation of trial. I was also served with, the papers yesterday, Your Lordship. And based on that, this court must hear that interlocutory application. If this court is of the view that the interlocutory application is of no merit, this court, of course, can dismiss it. If there is no further action, then this court, of course, would have merits to proceed with the main trial. So as indicated, Your Lordship, that is the only concern that I have. Of course, in as much as we want to proceed with the trial, there's those interlocutory applications pending before this court. So in my humble view, Your Lordship, even if Mr. Ricardo Gustavo appears tomorrow, this court still has to deal with those interlocutory applications. In law, how...
There's only one interlocutory application that this court has to deal with. That is the one with respect to separation of trial, isn't it? The other one, unless you are saying it's akin to an appeal, I'm sure an appeal suspends a decision, isn't it?
Indeed, the effect is so, Your Lordship, because how would this court proceed without knowing what the outcome of the Supreme Court would be?
The court, I don't see, you said there's ample authority. I don't see why a court cannot proceed until it is told by the Supreme Court that you should stop, or you were wrong in this decision or that decision. I don't know the ample authority you are talking about, but anyway, if you can give me one example and what the facts there were and what its effect is. The point with respect, say, to recusal, as far as I understand, is that it's really a question of prudence, because you can't proceed with a matter when there is that possibility that you will be the higher court will say that you were not supposed to proceed with the case. So it's more like an issue of prudence on the part of the court. Which way do you go? There are a number of applications which until they are determined, a court may continue with what it is doing. Just like, for instance, assuming there is an application for an interdict, isn't it? That application must be heard and determined. And the court is then told, you are not supposed to proceed, or you are interdicted. But it might be a question, depending on the facts and the significance of the application, it might be a question of prudence that they say, okay, there's an application for me to stop. I will stop until that matter is disposed of. But I'm not very certain that there is a law which will require that once an interlocutory application has been filed, all the main proceedings must stop until that interlocutory application has been filed. I will be quite grateful if you can draw my attention to a case to that effect, or to the rule.
Your Lordship, we had gone through this path, but for the sake of maybe repeating it, if you recall, Your Lordship, we had referred to the book Court Managed Civil Procedure of the High Court. Although this is a criminal trial, but interlocutory applications fall within the civil sphere. So there is a thin line, Your Lordship. And we had referred this court to Rule 32, subsection 2 of the High Court rules, which says that once an interlocutory process has been initiated and subject to the parties having complied with sub-rules 9 and 10, the managing judge must adjudicate an interlocutory motion within 30 days of it being brought. A ruling on an interlocutory motion must be given within 15 days of it being heard.
So, we were here yesterday. The interlocutory application, if it is one, for the separation of trial, must be disposed of when?
Your Lordship, it says there within 30 days of it being brought. And of course, the interlocutory application, from what I saw from the papers, the notice was given yesterday. So the proper procedure for this court, and I'm by no means speaking on behalf of Mr. Sakeus Shanghala, but I'm talking on procedural aspect. The proper procedure for this court is to determine when the interlocutory application will be argued, and for this court to pronounce itself in form of a ruling on that interlocutory application. Once this court has dispensed of that, that's when we fall back to the main trial and continue with the main trial, Your Lordship.
Why can't they go in tandem?
It is not possible, Your Lordship, because an interlocutory application, it suspends the main action.
Yeah, but that is where I've not.
If I may give an example, Your Lordship.
I've not received authority to that effect. That an interlocutory application, except for convenience, which I think, or prudence, necessarily requires that the main proceedings must stop.
Your Lordship, and that's why I said I don't want to seem like I'm arguing for clients who I'm not representing, but that's why I said I rise as an officer of the court, and I referred Your Lordship to Rule 32.2 of the High Court rules. And Your Lordship,
that rule, does it say it must stop?
It says, Your Lordship, maybe if I should read again, it says, the managing judge must adjudicate an interlocutory motion within 30 days of it being brought. A ruling on an interlocutory motion must be given within 15 days of it being heard, except if it involves a complex question of law. The ruling must be given within 30 days. So,
yeah,
Your Lordship...
But is it saying whatever else you are doing, the main trial must stop?
Your Lordship, it goes without saying, because the rule says there you must entertain the interlocutory application. So there's no way the court can entertain an interlocutory application in tandem with the main action. It's just like, if I'm to give an example of a criminal trial, a trial within a trial and a main trial. If there are issues in dispute, the trial within a trial suspends the main trial until issues are determined, whether admissibility issues are determined by the court or not. And then after that, that's when we fall back into the main trial.
This is why I said earlier, I think it all depends on the facts of an interlocutory application. If it is during the course of adducing evidence, and there's a challenge to the admissibility of evidence, of course you can't proceed until you determine that challenge. You see, because the real substance of it is someone is giving evidence, someone is objecting to the admissibility of that evidence. You can't proceed to hear that evidence until you have decided the question of admissibility. It's just like many objections which can arise during a trial. You have to deal with some of the objections either there and then, or depending on their complexity, at the appropriate time. But some of them have the effect of, or require that they must be determined before you can proceed.
Indeed, so, Your Lordship, and as Your Lordship has rightly said, for example, an issue of, one of those issues of the questions of, law raised in the 319 application of Mr. Shanghala is the issue of legal representation.
What does a prudent judge do if he thinks that there's no prospect of success?
Your Lordship, obviously, the prudent judge will dismiss that application if they are of that view.
No. I mean, let's say in respect of the petition.
Your Lordship, the issue of prospects of success, if that is the avenue for determination by the Supreme Court. I can understand, of course, that was already before this court. This court dismissed that application. Yes. But now, according to, the Criminal Procedure Act, the further avenue, in fact, the last avenue given to, an applicant who is not satisfied is the petition. So once it's dismissed, or if it is dismissed, by the Supreme Court.
My question is not the procedure. We know what the procedure is. My question is with respect to where, for instance, I have made my judgment on Rule 319. And I have the main trial to deal with, isn't it?
Indeed,
I believe that, yes, it's your right. You can go petition the Supreme Court. And I believe, or I am of the view, that there are no prospects of success. I decide that we proceed with the trial. And if I am correct, the petition is dismissed, the trial has been continuing, no harm has been occasioned.
Yes, Your Lordship, but looking at it conversely, what if the Supreme Court decides otherwise?
Then you stop.
But stopping, after you continue, why not determining the outcome?
That is why I agree with you. That is more a question of prudence and convenience rather than a question of law, that you must stop. But anyway, I don't think it's necessary for us to go on and on about this point. The only thing is, if it is a correct proposition of law, that wherever an interlocutory application has been filed, the main proceedings must stop, I'll be very glad to get direct authority on that. But I'm not insisting that you should do it now, but I'm just saying that is how I would be able to deal with it conclusively, because I'm not persuaded that any interlocutory application has the effect of stopping the main trial, unless the court determines that it is convenient or prudent to do so.
Your Lordship, I referred the court to Rule 32.2 of the High Court Rules. I cannot take that further, and just maybe my last point. Even if this court is of the view that the issue of the petition, that is, so to speak, the baby of the Supreme Court, what does the court make of the application for separation of trial? Because it has an impact on the main trial.
Well, that one will be decided. When it is decided, it is decided.
Yes, Your Lordship, but the question is because the application, the notice has been given. And that's why I said, according to Rule 32.2 of the High Court Rules, it's an interlocutory just like others. This court must determine it, and if this court is of the view that there is no merits to that, then this court would dismiss that application, and this court will rule further that we must proceed with the main trial unless there's anything else. That is the only reason I rose on my feet, Your Lordship.
No, that's all right.
Yes.
But yesterday, officers of the court we should have assisted the judge to say, no, Judge, the route you are talking about, papers being filed in terms of the rules is not the correct one. The correct procedure is that this application for separation of trials must be completed within 30 days.
Your Lordship, I'm sure this court would also consider that application was just brought to my attention, I believe everybody else's attention, only yesterday.
Yeah, but in terms of when you file papers and so on, that shouldn't be too difficult an issue for long practicing lawyers to know that, no, this application is by law required to be disposed of within 30 days. But anyway, it doesn't matter. We will come back to that later.
May it please the court.
Yes. Yes. Mr. Shanghala.
Judge, I'd like to begin addressing that issue you just exchanged with Mr. Siamunji on the issue of whether the interlocutory ought to have been brought under 32 or 65. And when I read 32.1, that's the rules, it says, the managing judge must give directions in respect of an interlocutory proceeding which a party has initiated or intends to raise with regard to the date and time of hearing of the matter, times for filing of heads of argument, and generally the speedy finalization thereof, etc. I take it that the issue of separation in the manner that I've encapsulated in my papers relates to the speedy finalization of the matter as it relates to those who want to proceed. But the importance of 32.1 there is that 32 doesn't say that you bring an interlocutory in respect of Rule 32. In fact, it reflects interlocutory proceedings, and it becomes interlocutory by the nature of the application before the court, is my argument. And in terms of 65, you then bring the application, because applications are brought in terms of 35, or if it's ex parte in terms of et cetera, et cetera. So I wanted to respond to the proposition that perhaps it shouldn't have been brought under 65, but rather under 32.
Is it Rule 65 you're talking about?
Rule 65 is the one that relates to applications. Yes, that's the one.
To interlocutory application.
No, what I'm trying to say, Judge, is that in the rules of the High Court, there are various rules and they have headings on them. There is a heading interlocutory at 32, but at 65, that's where you deal with applications. I brought this as an application under 65. I was trying to clarify that under 32, it doesn't specifically say you bring an interlocutory matter under 32. That it talks of interlocutories, the nature of the matter makes it interlocutory. It may be brought under another provision. That is what I was trying to say. In fact, 32 talks of proceedings. Which proceedings? The application proceedings which are now pending.
I'm not sure I grasp what you are saying, but you are saying you brought your application under Rule 65.
Yes, so I'm saying what makes a matter interlocutory is what is stated in 32.1. If it intends to raise with regard to the date and time of hearing of the matter, times for filing of heads of argument, and generally the speedy finalization thereof. But we know that this cannot be the only interlocutories. One was just mentioned by Mr. Mbangasi Omunji. An application for the recusal of a judge is also an interlocutory, but it's not mentioned here. We can't therefore say that it's not interlocutory. What makes it interlocutory is the nature of the application. The application before you is an application for a separation of trial, brought in terms of Section 157, and the vehicle that brings it before the court, the rules, is Rule 65. But it is still an interlocutory. Because if we become ultra-positivists and we want everything written down, and I'm glad that I'm speaking to a former legal drafter, you will find that it's impossible for the drafter to have anticipated everything. That is why Rule 17 says what it says, that the court will then manage the proceedings with the overriding objective to control and manage the cases in a manner that they are speedily resolved.
Your position, Mr. Shanghala, is clear to me. You filed your application for separation of trials, isn't it?
Yes, Judge.
And you stated the timelines for parties to respond and for the reply to be filed, isn't it?
Yes, Judge.
I didn't take issue with that. It is the new question arising that that application must be determined within 30 days, which I have been conversing with Mr. Siomunchi.
Yes, and I was getting to that. To say that Rule 32, is it 4? 32.4? No, 32.2 of interpretation of laws. There is a subsequent rule then that says that whenever an application is made, the government must be given, or the state must be given this period of time and that period of time. The question would be for the court to, because the rules are for the court, to make an interpretation and say, if it's an interlocutory, I don't consider the 15 days or the 21 days. And then I consider these days. I don't know whether it's for the court or for the rulemaker. I'm not so sure, but that is the question that is opened up by the discussion, that if it's an interlocutory, specifically, it would have to be done under Rule 32. It certainly wasn't done with the interlocutory that related to the recusal of the judge. So I only assumed that it would follow the normal DS. So that's as far as the issue that is raised is concerned. I then wanted to get to the issue of what then if Mr. Gustavo or all the accused people are here tomorrow, if we assemble here tomorrow, what would then eventuate? I wanted to start off by saying that there are actually three matters. One matter is for the determination of this court. Two matters are not for the determination of this court, but are germane to the activities of this court in this case. Those matters are the petition, which...
The only point I would want to be persuaded on, Mr. Shanghala,
Yes, Judge.
is just one simple one. Do all these petitions, applications, require that the main trial must stop? That is the whole thing. The rest about what it is, we know there's the Section 319 petition, we know there's the application to sue the judges, we know that there's an application for separation of trials. The only question is, do all those applications or any of those applications require that the court must not proceed with the main trial until those applications are determined? That is the only question here.
And
that is the question that impacts on what we do tomorrow.
And I think, Judge, it is a very central question that I propose that the time has come perhaps for you to request us to make submissions specifically on the issue. Because this is a case, and I've intimated it before, it's written, you have acknowledged that, will be fraught with many interlocutories to come, that we probably would want to be able to have certainty and make submissions to you so that you can make a determination on the issue, or at least be in a better position to consider the proposition against the backdrop of submissions made. I would suggest perhaps if the court could consider, yes, I can't find a better word to express that. So the guidance I was seeking is whether the question that we've just been discussing notwithstanding, the court will disregard those DS and rather just proceed with the taking of the pleas.
No, I'm not disregarding any DS. I'm not disregarding any DS. All I'm saying is that when that matter is mature for determination, it will be determined.
Yes.
I'm not disregarding those DS at all. And if you are correct that we have got that time lead, well, that is what it is, unless I'm convinced otherwise that that kind of application must be had within 30 days, in which case I would have to what they are according to you, but that to me doesn't mean, or as presently advised, doesn't mean that the main trial shouldn't continue. That one will come when it is ripe for determination.
I was just trying to imagine how we would do that. So we would then say, we proceed, pleas are taken, it would probably take a week or two to complete pleas, and then we follow the DS, that matter is considered. And then if the trial, if you are in fact convinced that the trial would be separated, what would then happen is the question I'm asking myself, what would happen? Would then have to start the pleas de novo, or would it have to, it's just getting a bit tricky in my view.
Yeah, but a separation of trial can be applied for at any stage, depending on the circumstances that have arisen.
Yes, and that is why I've applied for it at this stage.
Yes, you have, but that the determination has...
To get clarity, Judge, if I understand the judge correctly, to say, indeed, in terms of 157.2, you may apply at any stage, but it doesn't need to be determined when or immediately after it has been applied for. Is that how I understand the court? Perhaps I'm mistaken.
No, it depends on the nature of the application. Some applications are easy to dispose of, others come by way of application, the way you did it. It all depends on the nature of the application.
But I'm specifically referring now to the one in 157.2.
The one you filed?
Yes, the one that is pending before the court.
In terms of the one you filed, you have filed and set out the timetable for filing papers, isn't it?
Indeed, Judge.
And you, if I remember the dates correctly, you said something like the matter will be disposed of or be heard in November, isn't it?
Yeah. So following your train of thought, we revert back to the question again. Does the agency of the interlocutory suspend the main trial? Essentially, that's the question. And perhaps I can just then say, I really think it's the time to now authoritatively determine the issue, and that perhaps if the judge were amenable to inviting the parties to make submissions in that regard, the judge would be in a better position to make a ruling. And,
these are the submissions I'm seeking from you. There are different ways in which submissions are made. It's not always an opportunity to go and write the submissions. If you are in court, you submit if you are able to do so as the matter proceeds. Yes, and a question I've raised, and I've heard what the parties are saying, and unless there is much more that needs to be said, that's where the matter is.
Indeed, Judge. The reason why I take the view that I take is because the rules that we have are rather new. They are from 2014, 10 years ago. And the little research that I can do from the conditions in which I am, I couldn't find case law, and I'm relying on, hopefully, colleagues who are outside to assist me.
They're even newer to me.
Excuse me, Judge?
I said the rules are even newer to me than you.
Yes, Judge.
Yes.
And it would help with a little bit of reflection, and perhaps because things become a little bit different when you start writing them out. The articulation viva voce or viva voce is a bit different from that which is written. So I was just thinking along those lines, particularly because, Judge, as I indicated before, that I anticipate the matters that I've raised that the court is aware of to come will get us back into that discussion, and it requires determination again.
Yes. Is the Marondez anything? First, I want clarity here on the issue of the application for separation of trial. In your submission, what are the timelines? I didn't insist yesterday because I thought, well, that doesn't stop anything, and it will be heard in due course. What are the timelines for dealing with that application?
My Lord, it's unfortunate that we are bringing the civil rules into the criminal procedure. In terms of criminal procedure, my Lord, I don't know. Separation of trial is made immediately without, then if people feel that now at this stage the trials must be separated, application for separation trial is made immediately and it's dealt with immediately without these 20, 30 days notices. Because the trial should continue and the person wants to be separated so that the trials can continue. The application should be made and should have dealt with the application as soon as it is made, my Lord.
So you didn't hear what was happening yesterday here?
I heard about it, but we're going to file our papers, and this is going to be our argument, my Lord, that, look, there's no need of waiting for that. We should deal with the application for separation of trial. There's no need of delaying this trial any further. That issue must be dealt with immediately, and we proceed.
That seems to tie in with your position, Mr. Siomunji.
Indeed so, Your Lordship. The rules, although the rules, especially Rule 32, talks about 30 days, I mean, there is no reason why the 30 days cannot be waived to a shorter period.
Well, it was all in difference to the parties. You see, yesterday you received, I don't know how many pages it is. Before you even read it, you have a thick application, isn't it?
Indeed,
The assumption must be that people need time to read, respond, and so on. As I say, to me, it didn't really matter because there was no reason that application would stop the continuation of the trial until it is determined. Because even if a separation of trial has to come, of course, when we come to the point where the trial must be separated, yes, we come to that point. But anyway,
Your Lordship,
it seems to me then, just a minute, it seems to me that according to counsel here, and also Mr. Shanghala, who thinks that the procedures are not very clear, I would incline to the view that provided the papers are quickly filed, the issue of separation of trials must be dealt with quickly. But my fear also was piecemeal applications, and that's why I wanted to deal with everything when Mr. Gustavo is here as well. Because what will happen is you will get an application today by 3, we deal with that one, we come to an application by another saying I want my trial separated as well, and we can go in circles. But I am amenable to setting out a timeline for dealing with the application for separation of trials, and as soon as possible.
Your Lordship, that was going to be my next point, to say that the court doesn't have to be tied by the 30 days. Parties can agree to a shorter period of time. For example, parties can even agree to say maybe the matter can be set down for even next week to dispense with the application. And then thereafter, depending on the ruling of the court, that's when we can move on to the main trial. That is the last piece I wanted to add. May it please the court.
The ball is in the state's court.
Apologies, Judge.
Yes.
Before you pass that ball to the state, in theory, what Mr. Mbanga Siomunji submits to court is fine and well. The only difficulty with his submission is that the applicants for the separation of trial are in 1A prison. 2, in that prison they are separated. I am in a different section from where 2nd and 3rd applicants stay. We meet during the day for a maximum period, constructive period of 3 hours. If you were to abridge the times, I would request that that be considered in respect of the timelines that you impose upon the applicants.
For what? For the reply?
For the reply.
Yeah, but I thought, Mr. Shanghala, your
Yes,
wish is to, if I could make a decision, let's suppose your case was very clear that
Yes,
there must be a separation, isn't it?
Yes, Judge.
You would have even wanted the decision yesterday or today.
100%.
So what Mr. Siomunji is saying is in line with your desires, that it will be the issue will be disposed of very quickly.
And that takes me now to the very issue at the crux of the application for a separation for trial. Is that and I may be wrong, Judge, but I sense that the court is committed to the principle of a speedy trial, über alles, above everything else.
Yeah, we may be so, but I don't think you're correct. But anyway, carry on.
And the problem with that, based on my perhaps wrong impression of what the courts...
Yeah, but we can't lay a false premise and then want to build a case from there.
No, but the way the human mind works is that you understand something and then you act upon that understanding. Hence the application.
Yeah,
is
but
made.
what I'm saying is you cannot lay a false premise and say this court is concerned with a speedy trial above everything else, as a matter of fact. And I'm saying it's not
I'm
factual.
comforted to hear that.
Right. It's
I'm
not
comforted.
factual. There must be, people must be tried within a reasonable time.
Yes, Judge.
That is what the law provides.
Yes.
And the reasonable time depends on what happens in a case.
Thank you, Judge.
Right.
I'm comforted.
So, but we are dealing here only with your application for separation.
Correct.
You are saying you would want that decision made as soon as possible, isn't it?
Correct. And that in the process of it being made as quick as possible, could it be factored in the factual reality upon which I and my co-applicants are operating from, so that when you consider those DAs, you may consider the DAs of counsel who have the ability to consult their colleagues in the office and then have their access to JUTA and everything all throughout the day and night. I only have those 3 hours to consult with my 2 co-applicants, that be factored in. That is the only reason why I stood to say, before you pass the ball to
By which you mean what? Because all that remains for you is to file a reply when the other side or the other parties have responded to your application.
Yes, that is exactly.
And you gave yourself 7 days, wasn't it?
Excuse me, Judge?
Yesterday you gave yourself 7 days within which to do that.
Yes, that was what I was saying was.
Yes.
Oh, you've calculated the days.
I haven't calculated. I'm talking about what you said.
No, yesterday I said 15 days to the
I said
state.
the reply. How many days did you give for the reply?
14 days, which are in the rules.
Right, okay. Anything else, Mr. Shanghala?
Thank you.
Instead, we might as well deal with this issue. When are you able to file a reply, or any other parties?
But, my Lord, the state has some submission to make with regards to this separation of trials. The practice, my Lord, is that the separation of trial is done after the pleas have been taken.
Yeah, but you see, I don't want to get concerned about the lack of necessary guidance from counsel. If that is the position, these are the things we must talk about. Now we are bringing a new element to it.
Yes.
You are saying that the separation of trials must take place after pleas have been taken.
Yes, my Lord.
So you are saying...
Because at the end of the day...
No, this is why we must deal with the application to its end, right? You have an application for separation of trial now. Some of the pleas have been taken, others have not, isn't it?
Yes.
If it is your position as the state that this is premature application, that will be part of your defense, isn't it?
Yes, my Lord.
So the question is, if we accept that it is an interlocutory application which must be heard within 30 days, isn't it? Then we can tell the timelines for filing papers, isn't it? And then you come up with your position and say, this application is premature. It can only be lodged after the pleas have been taken. And if I'm persuaded by that, or the court finds you to be correct, that will be the position. The application will be struck off, if that is the position. But that constitutes what you are going to say in reply, isn't it?
Yes,
or in response to the application. Am I wrong in that respect?
That's correct, my Lord.
So,
But My problem is, I know that if the court can, if the court agrees with the views of the state and strikes off the application, that will not stop them from bringing again that same application after the pleas have been taken.
It doesn't matter, does it? If a person, you can't say to a litigant, don't bring this application. If it can't be brought at that time, or if it is wrong to bring it at that time, the matter will be dealt with. Isn't it the task of the court to decide on these various issues? You make your application like you say. If you are correct, he makes his application now. It's premature. We tell him it's premature. Make it after we have finished the pleas. Then we do the pleas. He comes back with this application. Want a separation. We carry on that way, isn't it?
As the court please.
So, of course, I'm not stopping you from making any further submissions. You still have further submissions. My question was in relation to the response to the application which came yesterday.
As the court please, if I might just consult my learned friend.
Let me again suggest something, because I'm concerned about Mr. Gustavo, right?
Yes, my lord.
I would want, I don't know whether Mr. Gustavo has been served with the application. Mr. Shanghala, you still haven't served on Mr. Gustavo?
I have served it upon him, Judge.
Yes. I am inclined to set out the timetable for this tomorrow. Because I would want to know from all the parties whether they are going to file any papers in support or in opposition, and then we take it up from there. Because if we finalize this issue about timelines for filing, Mr. Gustavo will come tomorrow and say, oh, I want to oppose as well, I need my time and so on. So I think it's neater when everyone is here. It may be inconvenient. It depends on your, Mr. Siamunji and Mr. Engelbrecht. You received the application, isn't it?
Indeed so. Yesterday, yes, Your Lordship.
It may be you want to say something about it in response, or you consider that is not anything to do with you?
There is that possibility, Your Lordship, but to take further instructions on that.
I can also confirm that indeed I received the papers yesterday. My Lord, let me go a little bit back. There's one question that the court have not engaged the state, and that is the question, what is the view about the petition? The state have not addressed that particular issue. Maybe perhaps the state can also engage on that particular point in order for us to sort out these issues for once and for all. As the court pleases.
Well, you reckon the position stated is the correct position, isn't it?
No.
In respect of the petition.
Yes, as far as that issue is concerned, the state have not made submissions on that one. So maybe perhaps the court can also engage the state on that particular score in order for them to make maybe a submission or their view on that particular point. Because if they are on my side as that particular point is concerned, then as far as the separation of trial also come into play. Maybe perhaps the state can also then enlighten us what is the view on that particular score.
In other words, you are saying 319 petition might mean that even the application for separation of trials should not be heard.
That is my view. So I don't know what is the view of the state on that particular score, because the court have not engaged the state on that particular issue, as the court pleases.
Yeah, views are not views are not very helpful to a court. There are submissions to be made, but anyway, I understand where you come from. My suggestion was, or my proposal was, we should wait until Mr. Gustavo is here tomorrow, since he's coming tomorrow. And in the meantime, you can all think about timelines for filing. I can tell you that I will be prepared to deal with this. You don't have to stand, you can sit. I am prepared to deal with this matter as quickly as possible, the application for separation of trials. But you are invited to comment on the effect or on the effect of the petition to the application for separation of trials.
My Lord, maybe he hopes that the state will support him, but the state will not do that. In this jurisdiction, my Lord, I know the court has said we should not say in this jurisdiction. We've had a situation in a matter where Mr. Samherji was involved in the matter of State versus Townsend and another. Petitions were filed. The High Court continued with the trial, pending the petitions. They said, we see when the Supreme Court answers, we'll deal with that, but we'll continue.
That's Townsend's case?
Yes.
Do you have a citation?
The actual...
I think there's some reference to Townsend in the application for...
Yes, my Lord. But the case number is CC 19 of 2013.
Mm-hmm.
Mm-hmm. So, my Lord, there's nothing that will stop this court from proceeding, irrespective of whether the petition has been heard or not. We'll get the result of the petition. If the petition is in favor of the accused, we'll stop there. If it is not, we'll continue. Those are my submissions, brief submissions, the response, my Lord.
But that argument doesn't apply to the application for separation of trials.
Yes, that's the application for separation of trials.
So, from the state's point of view, I consider that we should wait until tomorrow when Mr. Gustavo is here.
As the court, please.
But in the meantime, I would urge you to and guide you accordingly. I will set out timelines which require that papers be filed and that the application be heard before the end of next week.
As the court, please, madam.
My Lord, just the citation of the case, my learned colleague didn't put it accurately. It's State versus Marcus Thomas and another. Kevin Townsend, State versus Marcus Thomas and another. Kevin Townsend is accused too in that case. He mentioned him as if he was accused one.
Okay, so it will be the same same reference.
Indeed so, Your Lordship.
CC 19 of 13.
Yes, Your Lordship.
Okay.
May it please the court.
Yes, Mr.
Yes, morning, Judge. Just before you make the ruling for tomorrow, I've got another matter in court tomorrow morning, in the magistrate court, criminal trial, where we are making final submissions tomorrow morning. So I'll just like, either I'll be excused from the proceedings tomorrow, or the court maybe postpone it to the following day for me to attend.
Which court takes priority in this jurisdiction?
I don't know, not legally trained.
I think since you have filed your application, Mr. Hatuikulipi, you have filed your application, isn't it?
Yes, Judge.
Yeah, and I think tomorrow's business, as far as I can see, will be to deal with the disposal of your application as quickly as possible. And it may well be that you can be excused.
Okay, thank you.
Yes. Right, so I think the position is that we meet tomorrow morning. If you want to have more of your day, if we meet earlier, then you can leave earlier. If we can meet at 9, and then it's all up to you. But as I say, for those who want to deal with the application for be guided that the application for separation of trials will be dealt with quickly. Yes?
Judge, I have no qualms with the 9 o'clock if only I were at my house. I am not at my house. I am in a correctional facility where facilities are shared, and it's not every day that...
10 o'clock is fine with you?
Yes, 10 o'clock is fine.
That's fine.
Plus the complication that the police must escort Mr. Hatuikulipi to court and then etc. So the resources are limited. So I think 10 o'clock is fine, Judge.
No, that's all right. Right, so the matter is adjourned to tomorrow. The usual orders in respect of custody and bail are made. The court adjourns.